The case is now being recorded. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning and welcome to the Appeals Court. For those who are watching and wondering why we are off to such a late start with the first case on this morning's list in this session, I should explain that we just had the first argument for our newest justice, Margaret T. Grant, and I participated by tradition as part of the expanded panel for her first argument, and we had a brief induction ceremony preceding that argument. We're happy to have her join us, but now we can return to normal business with as normal as we can be during the pandemic, with case number 2019 P1683, the Commonwealth versus JONALSON DOR.
Good morning. May it please the court, Edward Crane on behalf of JONALSON DOR. The issue at the heart of this case is not immigration. The issue is the proper role of the legislature and the judiciary. The legislature makes the laws, the judiciary applies the laws in accordance with the legislature's intent. In 2004, the legislature instructed the judiciary to no longer tie the risk of immigration consequences to the word conviction. It is the judiciary's role to abide by the legislature's intent in this regard. In this case, the plea judge went outside that role. He determined that he made his own determination as to what constitutes an adequate immigration warning. This is not his prerogative. As the SJC recognized in Villalobos, the judiciary is bound by the terms of the statute. The legislature has instructed plea judges to no longer tie the risk of immigration consequences to the word conviction, and no judge can ignore this instruction. With respect to, I'm sorry, how do I know when someone's going to ask a question?
We'll let you know. Okay.
My apologies. I wanted to address the argument that the Commonwealth makes that this is.
Okay, the timer has frozen on us a little bit. I'll just note that for the record. We'll keep an eye on where we go from here. Okay.
Okay. The Commonwealth's argument is essentially that this is an immaterial, insignificant amendment to the warning, and I think that proposition completely falls apart when you look at the history that led to the amendment in 2004. So we have at the beginning the Villalobos case, in which the SJC recognized that using the word conviction can lead to confusion in these circumstances.
Would you agree that the confusion that the legislature was addressing was the application of the word conviction to the NOLO pleas or to the admission to sufficient fact rather than to a guilty plea?
I would acknowledge that. So I think this is where we have to look at what the SJC proposed and then what the legislature actually enacted. So I would agree that what the SJC was concerned with in Villalobos was primarily this situation where admitting to a sufficient proffering an admission and receiving a continuance without a finding under state law is not a conviction, yet under federal immigration law, it is a conviction. So the SJC in Villalobos was primarily, I think, concerned with that issue.
That implication is not implicated in the facts of this case, however, right?
No.
And you're familiar with the SJC case subsequent to Villalobos, Commonwealth versus Berthold.
Yeah.
That endorsed the analysis of a case from the appeals court, Commonwealth versus Agbogan, that identified the significance or the effect where the defect in the immigration warning did not implicate one of the concerns at issue in the particular case. How do you distinguish Berthold and Agbogan from the argument that you're asking us to adopt in this case?
So I think those cases really involve situations where the judge omits one of the one of the three enumerated consequences.
Right.
And what we have here is.
But here, what you have is the judge omitting one of the alternative means of effecting a conviction.
Well, I think it's not just that he didn't link it to a guilty plea. He used that word conviction. I think that.
Is there any question that a guilty plea produces a conviction?
Well, I think for a non-citizen, there certainly could be confusion. And I think that that's why the legislature, instead of taking the SJC's advice, which was essentially just leave the word conviction in there.
Follow up on that question. I've been trying to think of circumstances where you could have a guilty plea and not a conviction. And I've come up with two. One, you could have a guilty plea and then it could be guilty filed. And the other is if the Commonwealth no pros the case after the guilty plea and before the sentencing. Am I missing any other situations where a guilty plea and a conviction would be deaggregated?
I don't think so. And but I do think that this is sort of where we have to be careful in terms of looking at this from a judicial perspective or a legislative perspective, because what I think the legislature is concerned with is that non-citizens are not going to be able to make these distinctions between, oh, will this lead to a conviction or that would lead to a conviction, or even know what a conviction truly is. So I think this assumption, and this is sort of the primary argument raised by the Commonwealth, is that, well, the defendant must have known this was going to lead to a conviction because he pled guilty. That's precisely the assumption that the legislature rejected when it read the SJC's advice, which was to just add on essentially that an admission to sufficient facts followed by a quaff will lead to a conviction, can lead to immigration consequences, excuse me. And instead said, no, we're going to take the word conviction completely out of the statute because it's confusing. I think that we have to look at what the SJC recommended and then what the legislature actually did. And I think that's clear. What the legislature was focused on there was, look, the word conviction, no matter how you use it, is going to create confusion here because of all the different, first off, the different definitions of it that are used in the state and federal level. And then just a non-citizen will likely not know what a conviction actually is. So this idea that a non-citizen defendant, he would have known that this guilty plea would lead to a conviction. I think it's ridiculous, frankly, because that's essentially exactly the assumption that the legislature declined to adopt and essentially rejected.
I guess I'm looking back to, again, I don't know if you answered my question about distinguishing Berthold and Agbogan about why it doesn't matter that this doesn't attach to, that the expanded language doesn't attach to the circumstances of this case.
My apologies, Your Honor. I think that what Berthold is essentially saying is that the result, the immigration consequence complained of, has to be connected to sort of the inadequacy that is claimed. And in those cases, it's almost it's a little more straightforward in the sense that you have an omitted consequence, and then the defendant is facing a different consequence. So clearly in those cases, the inadequacy complained of is not related to the actual consequence suffered. But here, what we're talking about is really something different. We're talking about the inadequacy in the plea here is the what triggers immigration consequences. And here we're still using that language of conviction. And that is exactly what the legislature wanted to get rid of. We don't want to say that it's convictions that trigger immigration consequences. The legislature wanted it to be clear. So take out the word conviction because that's the root of the confusion, and insert the linking it to a plea of guilty.
But again, the confusion, again, maybe I'm missing something, but the confusion seems to me to be confusion around different circumstances than those involved in this case. It's a null pros or a quaff.
Well, I think that what the inadequacy is here and where the confusion lies is just the use of the word conviction. If the word conviction is used in this plea warning, that inherently creates confusion, and I think that's why
confusion as to whether it encompasses a quaff or an all-pros, but that's not what we have here, and that's why I hate to keep beating a dead horse, but it seems to me that's why I keep analytically going back to Berthold.
Well, I think that the distinction here is that again, I think, Your Honor, your analysis sort of takes the assumption that the defendant must know, because he's pleading guilty, he must know that he's being convicted, that there's a conviction here. And I don't think we can't accept that assumption, because that's exactly what the legislature rejected. The legislature did not want to make this assumption that a defendant who pleads guilty will know that he's being convicted. That's why they took.
I thought that the legislature's purpose was in making it clear that a defendant who agreed to sufficient facts with a continuation without a finding, or agreed to a disposition that null-pros the complaint, would understand, not that someone who's pleading guilty. I'm not sure where you're producing that.
Well, where I'm producing that from is again, go back to what the SJC recommended in Villalobos. In Villalobos, their recommendation dealt specifically with the problem of the word conviction is confusing when someone admits to sufficient facts for a quaff, because that's not a conviction under state law, but is under federal law.
Right.
But
that's not what we have here.
No, we don't. That's not what we have here. But what the SJC did was essentially, okay, to solve this problem, we suggest that you amend the warning so that, and their recommended amendment says, if it basically keeps the old language, says conviction of this offense, as well as an admission of sufficient facts for a quaff, may result in immigration consequences.
Right. But we don't have a null-pros. We don't have an admission of sufficient facts. We don't have a quaff. So why are the concerns identified in Villalobos, addressed by the legislature, implicated in the circumstances of this case? I just don't understand.
Well, the legislature went further than what the SJC recommended. What the legislature did was they went beyond the problem presented by Villalobos and decided that, look, this word conviction needs to be out of the statute because it creates confusion it could create potential confusion in every instance. And that's whether no matter what type of plea the defendant is proffering, the word conviction is the source of potential confusion. So we're going to take it out of the statute. So what I would claim is essentially that, look, if the plea judge ever uses this word conviction and basically uses the pre-2004 warning, that's inadequate, because what the legislature clearly wanted to do was take that word out, get that word conviction out of the statute. It creates confusion. And if it remains in there, the warning is frankly inadequate, because a non-citizen can be confused about what a conviction is. We can't make this assumption that all non-citizens, if they're pleading guilty, inherently know that they're being convicted of the offense. So I guess my position is, the defendant's position is, that any warning that uses this conviction language, that uses the exact language that was rejected, that the SJC rejected and then the legislature completely amended, is inadequate. And again, that's because of the inherent confusion in the word conviction. So this case is, I just think it's trying to fit it in along the lines of Berthold it doesn't fit along those lines of cases. I think really the issue that Berthold is dealing with is this instance where one warning is, one consequence is omitted and then another is suffered. I think that's sort of what we have to confine the Berthold decision to. This is something completely different. And I think we do have to look at the Pettit Home case, because in Pettit Home, the court was directly dealing with the issue of, not the issue of what immigration consequences were discussed, but about what could potentially trigger these immigration consequences. And you know, the SJC went in depth on that and found that that is important, that is essential. You have to follow the strict requirements of the statute in that regard. So I think Pettit Home is another case we have to look at with respect to the analysis here.
Anything further?
No, Your Honor. Thank you.
Thank you. For the Commonwealth?
Good morning, Your Honors. May it please the court, Houston Armstrong on behalf of the Commonwealth. This court should affirm the denial of the defendant's motion to withdraw his guilty plea because the immigration warning he received at his plea colloquy was adequate and it warned him of all potential immigration consequences. First, I would turn to the Petit Holmes case, which lays out a two-step test for the defendant to receive relief on an inadequate plea warning. Plea warning. First, the defendant has to show that he is potentially subject to one of the enumerated consequences. And second, he must show that he was not verbally warned of the specific consequence which he suffers. The Commonwealth does not dispute, and nor can it, that the defendant is subject to deportation back to his native country, so he satisfies the first prong. However, the defendant did not, at the motion stage of the trial court, nor can he here satisfy the second prong, where he was warned that as a result of his conviction and guilty plea and subsequent conviction, that he could possibly be deported. And that's exactly what happened here.
Do you agree, I know this isn't this case, that if a defendant pled guilty but was not convicted, one of the scenario I laid out, and got deported because of that, that he would have a claim if this kind of instruction was given?
Certainly, Your Honor. I would agree that he would have a claim. Whether or not that claim would be successful is another question. And for that proposition, I would actually cite to a brief I just came across an unpublished decision out of your court I came across last night, which was not in my brief. It was published on August 7th, 2020. The defendant's name is Julio Espinal. The docket number was 2019 P0655. And the reporter was 98 Mass App Court 1107. And in that case, there was some confusion about whether or not the defendant was pleading guilty or admitting to sufficient facts, because the plea judge, instead of saying conviction or admission to sufficient facts or plea of nolo contendere, he just referred to what was happening as the disposition. He asked the defendant, "Do you agree with the disposition of this case?" The defendant said, "Yes, I agree with it." This court affirmed that warning as adequate and affirmed the denial of his motion for new trial. So I would say that that's very analogous to the situation where we have here, where our case is even more specific than if you're not referring to what the precise disposition is. And Justice Ditkoff, to your point, I think here where the motion judge is consistently referring to guilty plea and conviction throughout this entire time, specifically on transcript page 24, 27, 28, and 29, he's using guilty plea and conviction. He's never using disposition. He's never saying admission to sufficient facts. He's consistent throughout the whole thing, because here the defendant was in fact pleading guilty, which would result in a conviction. And even more, I would piggyback on what Your Honor said, Chief Justice Green, about the Berthold case, where simply establishing a defective warning does not entitle the defendant to relief. Where here, I would not concede that there was a defective warning. I think it was an adequate warning. But the defendant was warned precisely of a potential immigration consequence that came to fruition, and that doesn't entitle him to withdraw his case. And while I say it was an adequate warning, I think that The Lamrini case is still good law, just as reiterated in Petit Holmes, that the language is the reading of the statute and the language is to be relatively literal and strict. It does not say it must be literal and strict or it has to be the exact language. It is relative. And here, that's exactly what happened here. This was a guilty plea.
I think there was some question among a lot of us at the time whether Lamrini, in its broadest application, survived Soto, Justice Sussman's opinion in Soto. The SJC back in those days was sending some fairly clear signals that they expect the immigration warning to hew closely to the statute. I can remember the late Justice Sussman saying, "Why can't you just say what's in the statute?"
I agree with you, Chief Justice Green. I think the best practice would be to read the warning as provided by the statute. But the SJC has also said that just because there's an inadequate warning, a defendant is not automatically entitled to relief. And
Well, Berthold is really the only instance where they've overlooked a departure from the strict reading of the statute.
But again, in Berthold, that was one of the immigration consequences, which is the main, arguably the main focus of the immigration warning is what are the potential consequences for this disposition. I agree that the confusion that Justice Hand mentioned that was discussed during my brother's argument about whether it's a guilty plea, admission to sufficient facts, or nolo contendere, there is a bit of confusion for whether or not the defendant understands whether his state disposition could be subject to federal immigration consequences. But in Berthold, you're looking specifically at what the immigration consequences were and whether or not the defendant received that advice. And in Berthold, he received the precise advice, which he then suffered, which the SJC affirmed and said that although that plea colloquy was inadequate, it is sufficient to put the defendant on notice. And here we even have a more precise plea colloquy and immigration warning than was in Berthold that was affirmed. And so I think, yes, best practice is to read the statutory language as it is provided. What the judge did was depart a little bit here and hone in on what was going on. It was a guilty plea, which resulted in a conviction. And the judge was precise about that from the very beginning. So there was no way using those words consistently in the way in which he did could not have led to any sort of confusion. If there's no further questions.
Seeing none, I'll thank you for your argument. Thank you both. The case is, thank you.
The case is now being recorded.
Okay, our next case on the list for hearing this morning is case number 2020 P54, the Commonwealth versus Ashley Jones. You may proceed.
Good morning, Your Honors. May it please the court, my name is Attorney Alicia McNeil, and I represent Ashley Jones. I have 3 issues before the court today. The first issue is, was it reversible error that the trial judge did not allow the motion for directed verdict at the close of the Commonwealth's case because the Commonwealth's evidence was insufficient to meet the burden beyond a reasonable doubt that Ms. Jones was the operator? And in this case, as Your Honors know, the main issue is who the operator of the car was. In looking at this case in the light most favorable to the Commonwealth, the case was insufficient to warrant this case even being submitted to the jury. The evidence was speculative and one of conjecture. The evidence could equally sustain an inconsistent proposition of either innocence or guilty, according to Commonwealth v. Shea. Looking at the evidence that was presented before the court, the primary witness, Gold, testified that he was stopped at a light for approximately 5 to 15 minutes, depending on what he said during his testimony. He never felt an impact on his box truck. He never heard the car crash in the back of his box truck. And he did not even know when the impact occurred. What he said is that he saw a glow in the side view mirror. He got out of his truck to investigate. He didn't know how long the car had been there. He saw a female get out of the driver's side, a male get out of the passenger side, and then he heard a clicking as though someone was trying to start the car. Another very salient point is that Officer Tavares testified that after he arrested Miss Jones, she said, "It wasn't me." Officer Tavares was also shown two videos by the trial attorney, and two photos by the trial attorney. These photos, he said, was a fair and accurate representation of Miss Jones at the time of his arrest. And that is in Record Appendix 7. These photos showed Miss Jones with a burn mark on the right side of her neck, which could be inferred that that's where a seatbelt, she'd been sitting in a passenger side, a seatbelt was.
Well, certainly that's fair argument to the jury, but the question of sufficiency under Lattimore requires us to look at the evidence in the light most favorable to the Commonwealth, right?
Yes, that's correct, Judge.
And we do have a precipient observation of her getting out of the vehicle. The only person that we have getting out of the vehicle on the driver's side is your client, the defendant, right?
Well, that's the question, Judge. We don't know if it's my client. It's a female. She was never identified at the trial, nor was she identified.
Well, let's. I think we've got more important things to talk about than that question, don't we? A female was recognized getting out of the vehicle, and the responding officer who responded moments later, there weren't many other females in the area who had any connection to the vehicle. There weren't any. There weren't any.
That's correct, Judge.
Let's accept for the present conversation that a rational finder of fact could conclude from the evidence that we have that she was the person who got out of the driver's side. I take it that your argument is that the mere fact that she was seen getting out of the driver's side doesn't mean that she was driving at the time that the car became lodged under the truck.
That is my argument, Your Honor.
Okay. There was a jury could infer, a relatively brief interval between the time when Mr. Gold saw the flash of light looming in his side mirror and got out of the car. The flash of light could well have been the headlights of the car approaching and then ultimately lodging beneath the rear of his box truck.
Your Honor, Mr. Gold testified that he got out immediately after he saw the glow in the side view mirror.
And so a rational trier of fact could infer that glow was in fact produced by the headlights of the approaching vehicle that ultimately collided with the rear of the box truck and lodged underneath.
I would respectfully differ in that opinion, Judge, because when Mr. Gold got out of his box truck, the car was already secured under his box truck.
Correct, but the flash was before he got out,
Yes.
and he said he never heard the impact. So we can rule out any noise as a contributing indicia of a collision. But if we accept for the moment the possibility that the glow was from the approaching headlights, his inspection to see what might have caused that glow discovered the car underneath the truck, right?
That could be a way to look at it, Judge. However, my argument,
a rational way to look at it?
It could be, Judge, and there is another way to look at it. And the other way is that Mr. Gold did see a glow in the side view mirror, and after he saw the glow, the car was already underneath the truck. It was securely under the truck. He never testified that after he got out of the truck that he heard an impact. He never testified that he felt his truck move after when he saw that glow. The car was already securely underneath the truck. I would like to move to my second point. I see that my time is running. If there are no further questions regarding that first point. So on that first point, I would ask that your honors would find that would set aside the verdict and remand this case for a verdict of not guilty. My second point would be burden shifting. And I would argue that the Commonwealth shifted its burden during the closing argument when they improperly properly suggested to the jury that they should look at Miss Jones for a reason as to why she ran. And as a result of that, there was a substantial miscarriage of justice, risk of miscarriage of justice, and therefore reversible error, which violated her rights. Looking at
under these circumstances and looking at the argument as a whole, why was that set of questions not asking the jury to assess the credibility of the defendant as a witness when the defendant had chosen to testify to that particular set of facts?
Well, the reason why it's not looking at the credibility of the witness is because the way that the Commonwealth phrased the questions and it's okay that and I agree that when commenting on the plausibility of a defense theory that the Commonwealth and the prosecutor can focus on the evidence that's produced by the defense. However, the evidence has to show that what they have to basically focus on is the evidence itself rather than on the defendant, in this case, Miss Jones, and what she showed or failed to show. And in this case, the Commonwealth shifted its burden when it focused more on Miss Jones as to what she should show or what she should not show. The Commonwealth essentially, rather in looking at the burden shifting, we look at the anemic factors, and there was no objection, as the court knows. There was no curative instruction by the trial judge. If you look at the issues that would have been affected by this error in the closing argument, it went to the heart of the issue of the trial, and that is operation. And finally, the Commonwealth's case was so underwhelming that shifting the burden to Miss Jones to prove why she ran was really prejudicial.
The fact was that she did leave the scene, right?
She did, Judge.
And why is that fact, standing in and of itself, not fair comment on consciousness of guilt?
Judge, it would be fair comment if the Commonwealth had rephrased the question. However, the way that he asked the question, why did she run? That's the question that you should look at. Why did she run? If he had phrased the question differently in terms of looking at the, you heard the testimony of Miss Jones, and you can determine whether or not it's credible looking at the totality of the testimony. That would be different. Here, he put the burden on Miss Jones to clarify why she ran, even if she didn't testify,
the fact that she left would have been fair subject for comment on consciousness of guilt, would it not?
It would have been, Judge.
Okay, and so when she chooses to testify and offers an alternative explanation for what she's doing, why is that inculpatory consciousness of guilt not fair grounds for impeachment?
Judge, because again, it's the way that it was phrased, and it was really focusing on Miss Jones showing proving whether or not she, proving why she ran. So the burden shifted to her. It wasn't as though he was looking at the totality of the evidence itself. His focus by run was more focused on Miss Jones and what she showed or failed to show in her testimony.
Yeah, I think we have that one. Do you want to say anything about your argument on newly discovered evidence?
Yes, Judge, I would like to. As far as the motion for a new trial, I would ask this court to remand this case for a new trial in the fact that there was an error and an abuse of discretion by the trial judge. I think what the trial judge did is the trial judge looked at the newly available evidence versus newly discoverable evidence. And looking at newly available evidence, as your honors know, the trial judge has to determine whether the newly available evidence was credible. Newly available evidence does not mean that Ms. Jones did not know about the testimony of Meharg. Newly available evidence does not know.
How do we know that the testimony of Meharg wasn't available at the time of trial?
The trial attorney subpoenaed Mr. Meharg.
Well, how do we know that?
If you look at Record Appendix 4, you can see on the docket sheet that he was subpoenaed from Middleton House of Correction on, I believe it was June 7th.
Was that for the trial date, on the date the trial actually took place?
Yes, it was, Your Honor.
And how do we know that?
There is an actual actual document which shows that he did subpoena Mr. Meharg. That is not included in the record, as inadvertently was not included.
You know that, but we don't.
Yes, you don't, but it is in the record that he was subpoenaed. And if you look at the record, if you look at the docket sheet, the only reason why I would argue why a witness would have been subpoenaed, particularly Meharg, would have been for a trial date.
But the nature of what the defendant would have expected him to say was certainly known to the defendant at the time.
Yes, Judge.
Okay. And what efforts were undertaken either to get a continuance or to enforce the subpoena?
There were no efforts taken by the trial attorney, Judge, for those two things.
So what is it that makes this newly discovered evidence rather than ineffective assistance for failure to exert reasonable efforts to obtain the presence of the attorney at trial? I mean, the witness at trial.
Judge, it's newly available. I would argue it's similar to a case where a person is standing there and decides that they're going to assert their Fifth Amendment right, and then later changes their mind and decides then that they are going to testify at some later date.
I'm not sure, because the unavailability is not as structural as it on the facts as they exist at the time of trial. In this case, as they would be if someone is invoking a privilege.
Judge, I would argue that it is similar. It may not be exactly the same, but it is similar. And the fact that the trial attorney did not do anything further to secure the witness's appearance on that date, it could be ineffective assistance of counsel, but it also could be that it's newly available evidence.
We don't have it here on ineffective assistance, and part of the reason we don't is because we don't know, in fact, what the circumstances were at the time. You're asking us, so we're now looking at whether this was, in fact, newly discovered against the very high standard that doctrine requires.
Judge, I would ask that this court look at this matter as newly available evidence and remand this case. I would also say there was abuse of discretion in my last 10 seconds, abuse of discretion where the trial judge, the motion judge, did not bring Mr. Meharg in to assess his credibility.
Thank you.
I thank you, Your Honors.
Okay. For the Commonwealth.
May it please the court, my name is Nicole Lynn Nagin, and I am an assistant district attorney with the Middlesex District Attorney's Office. Turning to the first issue addressed in the Commonwealth's brief, the trial judge correctly denied the defendant's motion for a required finding of not guilty because any rational juror could have found that the defendant operated the motor vehicle on January 11th, 2018. And as your honors notice, that if we look at the evidence in the light most favorable to the Commonwealth, what it demonstrates is that Mr. Gold testified that once he saw lights in his rear view mirror, my sister stated during her argument that he immediately got out of his boxcar and walked to the back of the truck. And within seconds, he saw a car lodged under his vehicle. and a female driver get out of the driver's side and a male get out of the passenger side. But the other evidence that is also helpful to the rational juror's conclusion is that Mr. Gold saw the rear view lights in his side view mirror, but he also testified that when those lights disappeared is when he got out of his truck. And so a rational jury could conclude, well, the lights disappearing was exactly when the car got lodged under his truck. Moreover, the testimony was not only that he saw a female driver get out of the driver's side, but he also saw a male getting out of the passenger side. And so a rational juror could also conclude, well, surely both individuals were getting out of the car due to the direct impact that had just occurred. Additionally, there was further testimony that that female then re-entered the driver's side of the car. And so if we look at all of that evidence in totality, in the light most favorable to the Commonwealth, any rational juror could have concluded that that female, the defendant, who claimed ownership of the vehicle, who was found close by to the vehicle, and who in fact was the registered owner of the vehicle, was surely the individual who was driving that car when it impacted Mr. Gold's boxcar. If there are no further questions onto the first issue, I will turn to the second issue addressed in the Commonwealth's brief. The prosecutor's closing remarks properly asked the jury to draw reasonable inferences based on the testimony of the defendant, and in no way created a substantial risk of a miscarriage of justice. And I will note, Your Honor, that Chief Justice Green mentioned a very important point, which was conscientiousness of guilt. After the prosecutor presented their case—
I think you mean consciousness.
Yes, Your Honor. After the defendant testified and on cross-examination was asked why she ran, the prosecutor requested an instruction as related to flight. And the trial judge indicated that she would not provide such an instruction, but that both parties could argue the issue of flight in closing. And the Commonwealth, of course, did not object, nor did the defendant. Moreover, during defense counsel's closing argument, she made an argument regarding the defendant's flight. If we look to the transcripts on page 133, the defense trial noted, quote, "Miss Jones was running from nothing. Yes, she fled the scene. She told you she was going after Mr. Maharg, who had her purse and her keys. But on the other end of the town, she's walking." So the prosecutor had the right in their closing argument to respond to arguments made by defense counsel in closing, and also to respond to the exact testimony that defendant provided on cross-examination, whereby she explained that she was chasing after Mr. Maharg. It's also important to note that Mr. Gold, during his testimony for the Commonwealth, indicated that when he said he was going to call 911, the female driver, the defendant, begged him not to on multiple occasions, and that once he had called 911, she left the scene. And so surely the jury was entitled to reflect on those two contrasting pieces of evidence and determine whether the explanation provided by the defendant was in fact credible. Because the defendant testified to these issues, because there was no objection, and of course, because the trial judge provided all the proper instructions about who bore the burden of proof and that the arguments made by counsel was not evidence, there could have been no substantial risk of a miscarriage of justice based on the statements made by the prosecutor in closing arguments. If there are no further questions on this issue, I will turn to the final issue addressed in the Commonwealth's brief. The trial judge properly exercised her discretion in denying the defendant's motion for a new trial because the post-trial affidavit of the defendant's boyfriend was not newly discovered evidence. And I would like to respond to the two issues raised by my sister in regards to this issue. The first, that the trial judge supposedly made a factual error in finding that the information in Maharg's affidavit was not newly available. And as this court knows, when the motion judge is also the trial judge, we give particular deference to findings of fact if they are supported by the record. And if we look at the record on page 39, the motion judge's decision indicates, quote, that Mr. Maharg was not called as a witness at the jury trial. The defendant was aware of Mr. Maharg's involvement in the facts of the case. The defendant made no effort to secure the testimony of Mr. Maharg for the trial. And the assertion—
Let me stop you there, because as your sister pointed out, that is wrong. Because it's right there in the docket sheet that counsel asked for a Habe for Mr. Maharg. So that statement is in fact incorrect. Don't you agree?
So I would answer your question in two parts, Your Honor. My understanding of the record, and apologies if I'm incorrect, was that Mr. Maharg was subpoenaed for the second trial date that was then postponed. I did not see a reflection on the docket that he was in fact subpoenaed for the third trial date, which was in August. I only saw a reflection of July. That being said, the fact that an individual is subpoenaed, a judge may find that that is not sufficient to make sure that a witness is present. There were many things that the trial attorney could have done to secure the testimony of that witness, if in fact it was essential to their case or if they deemed it relevant. And as this court noted, there is nothing in the record to reflect that. So the trial judge's assertion, who was also the motion judge's assertion, who was also the trial judge and admittedly witnessed all of this at the time of trial, when she concluded that the purported testimony of Mr. Maharg was unavailable is speculative, is a proper conclusion for that motion judge to make based on the record before her and based on the assertions of counsel in the motion for a new trial. There is no information besides the fact that there was an earlier subpoena. There is no assertion of what he would have said if they brought him forward or what privilege he may or may not have inserted. And so the simple fact that there may be a record reference to being subpoenaed is surely not sufficient to say, well, therefore he would have asserted a privilege and all of the information would not have come in there then and is only available now. Moreover, the simple fact of asserting the privilege in and of itself would not mean that the evidence is newly available. And I think that that point is significant because even if this court wanted to find that the subpoenaing would make him available, the motion judge could still find that the evidence provided was not newly available in that it was all known at the time of trial. And that was of the prerogative of the motion judge to make that determination. And so there was no factual error in finding that the evidence was not newly available in the sense that he could have been subpoenaed. We don't know if he was, but he didn't assert a privilege. And so we don't know what it would have been provided at testimony. So therefore the motion judge was correct in saying that everything is speculative. And so therefore not crediting that it was newly available. I would also like to address the point that my sister makes as to an abuse of discretion. And she indicates that the motion judge failed to make a credibility finding, which she was required to do. I would first note that if the motion judge found that the evidence was not newly available, that ends the inquiry and is a basis in and of itself by which a motion judge can deny a motion for a new trial. That being said, here the motion judge particularly commented on the credibility of Mr. Maharg's affidavit. The motion judge noted in record appendix on page 40 in her opinion that Mr. Maharg's affidavit was provided over a year and a half after the incident. And she noted that the assertion of any privilege is speculative. And so while she did not explicitly state that Mr. Maharg's affidavit was not credible, the statements made in the memorandum decision of the motion judge indicate that the information provided in that affidavit was not credible to the motion judge, who was also the trial judge. If there are no further questions on this issue or any of the other issues I have addressed today, the Commonwealth would rest on its brief as well as the arguments made today.
Chief, can I just say, this has been a simply wonderful oral argument. I hope we'll see both of you a lot more often.
I was thinking the exact same thing. You both did a terrific job. Thank you.
Thank you, Your Honors.
Thank you, Your Honors, very much.
Okay. That will conclude the argument in this case. We will return to the waiting room and admit the next set of attorneys. So the case is submitted. I should also, I'll say it when we get live.
The case is now being recorded.
Okay, our next case is case number 2019 P1593, the Commonwealth versus Walter Creighton. And I should add that the panel has requested and obtained the photographs that are at issue in this case. We have viewed them before preparing for this argument. So you may presume our awareness, not simply of the narrative descriptions contained in your respective briefs, but with the images themselves as you proceed with your argument. With that, Mr. Hirsch for the defendant.
Thank you, Your Honor. If it please the court, Mr. Chief Justice David Hirsch representing Mr. Creighton, I'd ask the court to consider the case of Commonwealth versus Beam, in which the photograph at issue showed a physically mature, that was the description, 15-year-old girl with an exposed breast embracing her boyfriend. That was considered not lascivious under 29A. And the court explained, leaving aside the partial nudity of the subjects, the photographs do not show sexual behavior or depict a sexually oriented display, are not in a setting generally associated with sexual activity, and do not evince sexual suggestiveness or a willingness to engage in sexual activity. And then the key sentence, whether the breast is the focal point of the pose is, in this case, a subjective assessment of little relevance. The photograph is of an embrace between two people, and the chests of both subjects are accordingly in the center of the photograph. That is the same, Your Honor, as with all of the photos involved here, except perhaps 13 and 14. All of these children have somewhat developed breasts exposed, but that's because they're photos of the entire children, with the exception of the bottom of the legs. Compare it to the photos in Rollins, where the back was severely arched, the buttocks were jutting out, there was a kissing face, there was an unnatural pose, and more importantly than anything else, in one of the pictures, one child had her hands on the breast and buttocks of the other. Nothing of this in these photographs has that kind of sexual patina, that kind of sexual reference. Compare it to the Dost case, where the focal point of the photographs are the girl's well-developed genitalia. Indeed, some of the poses border on the acrobatic in order to obtain an unusual perspective on her genitalia.
Mr. Hirsch, do you agree that if any of these pictures is lewd, that is sufficient?
I would have to say so, yes, Your Honor.
The unit of prosecution is the cash, and so if any one of these is pornography, then or is lewd, then the conviction is supported.
I would agree with that, Your Honor.
So let's talk about two. In one image, there are 5 girls naked with their arms around each other, each holding a number. In offering a defense of that image, you suggest that the children likely have far more innocent reasons for holding numbers than illicit ones. That may be true if they're not naked. I'd like you to describe for me the innocent explanation behind naked girls standing outside with their arms around each other, each holding a number.
Very well, Your Honor. Among other possibilities, there have been games going on in which they have been numbered. They have been...
What kinds of games that they're engaged in while naked?
Any kind of camp-type games or beach-type games. the number of possibilities is limitless. In fact,
well, I'm rather than offering a broad description, I'd like you to get into the specific detail, because I'm struggling. This is not at a beach. This was in the woods, and I'm I guess struggling a little bit, other than some sort of ranking system going on. The idea that if they were clothed, if they were in athletic gear, the games of competition comparison seems like it may have some traction. I'm struggling a little bit to come up with the innocent explanation of the numbers in this image.
Well, Your Honor, let's assume for the moment that they are being ranked. What are they being ranked on? We have no idea. It could be height, it could be age. Certainly, it could possibly be something having to do with development, as the Commonwealth says, but that's purely speculative. We don't know, we can't guess. Otherwise, we can find some kind of sexual meaning in anything. We know that it's a natural setting, whether it's the beach or the woods, and that none of these
natural, but the nakedness is not.
But the nakedness itself is not, should not be the subject of prosecution, even where specific body parts are shown, as said in Osborne versus Ohio. It's not the fact that breasts or genitals are shown. It's whether that portrayal is lewd. And here it is innocent as can be. There is absolutely, in fact, I think the best way of—
Justice Ditkoff has a question for you.
Why isn't it suspicious that each of the placards is held really in the only place where it wouldn't obscure any breasts or genitalia?
I hadn't even noticed that, Your Honor, but I think when you consider that two of the girls, I think, are not holding placards of any kind, all we have here are girls holding placards, and we can read anything we want to into it, but that cannot possibly provide proof beyond a reasonable doubt. I think—
Let me ask you, Mr. Hirsch, while we're at it, to comment on the last image, which shows a girl in a naked girl in a pose with her arms forming the shape of a heart above her head. In your brief, you suggest that she could simply be carrying out the pose as that of a ballerina. And again, I guess one of my questions is if her ambition were to be a ballerina, where's the tutu?
Well, once again, if that's the determinant, we are criminalizing the mere fact of child nudity. We are criminalizing the mere fact
No, but
of
it's the pose along with the nudity. You have to take, you can't parse these in isolation. You know, you also comment that again, that if the image or the shape of a heart is a demonstration of love, that there's nothing wrong with that other than the nakedness. But I don't think you get to take the nakedness out of the equation for purposes of making that argument.
I think, Your Honor, you've just gotten to the heart of the issue. And that is looking at all the cases, looking at Dost, looking at Fabrizio, looking at Wolf, Abero, Sullivan, Rex. We have these cases together present a collective benchmark. Would there be anything about the photo if the children that would be sexual if the children weren't naked? And I suggest if you take away the nakedness and there's nothing left that's sexual, it cannot be lewd.
Why isn't the nakedness the starting point, and then you consider the nakedness in the context of what other elements are present?
Because we have the rule that mere nakedness is not criminal.
I'm not talking about mere nakedness. I'm talking about nakedness in context.
Oh, and so am I, Your Honor. And we're talking about nakedness in context with all innocent activities, with all non-sexual poses, in context with no sexual meaning of any kind. Maybe
I misunderstood you.
I'm having a lot of trouble hearing you, Your Honor.
Maybe I misunderstood you, but if there was a picture that was just a close-up of a child's naked breasts, that was the only thing in the shot, would that be lewd?
There is case law supporting that, Your Honor. And it's still very hard to hear you, but then there would be the focus on the breast, which there is not here. To the extent that breasts are shown in the center, it's because they're portraits of children standing up.
But can I ask a question?
Judge Hand has a question for you, Mr.
Yes, sir.
Could I ask, can we take into account in our consideration not just the nakedness, but the artificiality of the positioning? For example, with respect to the last image, the chief was talking about the girl standing in the hands over head position that you've put into ballerina context. Looking at that girl, where the fact, for example, that there are tan lines evident on her body suggests that nakedness is not the state in which she ordinarily goes to the beach or frequently goes to the beach. The fact that she is in this particular location doing what might be an innocent activity, but doing it in the nude, can we consider that level of artificiality as part of the construct here?
I'm not sure what Your Honor means about the artificiality of that picture.
I guess assuming that, and I understand you see it differently, but say the five girls lined up in height order, varying in apparent age with the placards. I understand your point that that might be an indication of some kind of game, but assuming that we are not persuaded by that argument and find that to be an unusual arrangement under the circumstances, is the fact that we, even if there is no explicitly sexual act taking place at that time, can we consider that?
An explicitly sexual act is not necessary.
Right.
But again, I would argue that in all of the cases, the courts have looked at what are they doing? Is it sexual in nature? Is there a specific clinical focus on genitalia or breast? The example that Justice Ditkoff provided is a clear one. If there was a picture of a breast, we could reasonably infer that there was sexual meaning there. We cannot from somebody in a heart or dance pose. We cannot from people holding placards. Here, as in Rex, the visibility of the children's genitals is merely an inherent aspect of the fact that they are naked. There's nothing remotely sexual, either explicitly or implicitly, in the photocopies. If we look at, Your Honor raised the question of the tan lines. That proves only one thing, that sometimes she wears a bathing suit, and it proves nothing else. The fact that she doesn't always go naked, well, I don't always wear a suit, Your Honor. There is no real meaning to it. It would be pure speculation to say anything about tan lines showing on breasts and genitalia, and the head was barely visible. That would be a sexual focus. The fact that this isn't her standard routine is not. We have Justice Holmes' famous sentence, any conclusion can be given a logical form. And if we try hard enough, we could find anything to be lewd. But if we were to do that, all the protections of Rex and Osborne and similar cases would disappear. Mere nakedness is not enough. Mere nakedness plus something that wouldn't be sexual if there were not nakedness cannot be enough. We can say, take all of the photographs the same way. Would the girl's alleged smirk in Exhibit 11 be sexual if she were clothed? How many meanings could we give that smirk? Daddy, are you taking another picture? Or maybe it's not a smirk. Maybe she has a funny smile. The arms in the shape of a heart, again, that is speculative. We can look at it as somebody who is just being the ballerina, somebody who has her hands in the shape of a heart. For what purpose? We have no idea. One that's particularly outrageous to me is the picture of the girl holding a cat. If that girl were clothed and wearing a cat, would anybody consider wearing and carrying a cat? Would anybody consider that sexual? No. Unless there are any further questions, I rest on the briefs, Your Honor. I thank you.
Thank you. We'll hear from the Commonwealth.
Good morning. May it please the court. Megan Monahan on behalf of the Commonwealth. Appealing his conviction for possession of child pornography, second offense, the defendant only contests whether the 6 images found in his possession constitute a lewd exhibition of the unclothed genital, pubic area, buttocks, or fully or partially developed breast of the depicted minor girls. Here, where a rational trier of fact could find that multiple DOST factors apply to each image, the evidence was sufficient and the defendant's conviction should be affirmed.
Ms. Monahan, let me ask you the same question I asked your brother at the start of the argument. Do you likewise agree that if any one of these images is lewd, the conviction must stand?
Yes, Your Honor.
You don't need to establish that each of them is, even though I heard you make that argument. But let's focus on the 2 or 3 that you consider the most easily established.
Yes, Your Honor. So the conviction would stand on any one, and all images here would constitute a lewd exhibition. Drawing back to the ones that have been spoken about before, the 5 girls arranged in order from least developed to most developed. Again, there is no game that comes to mind or an innocent version of this picture, especially where it's not ranked in the sense of height or age, but based on the image itself and reviewing that image, it's apparent that it's based on developmental order from least developed to the most developed minor, who was between the ages of 14 and 17, where the others were roughly in the range of 10 to 14. And the pose in exhibit, I believe it was 15, where the love and the shape of the heart, that's significant in sense of combining it with the tan lines, which draw the viewer's gaze to the breast and pubic area. Contrary to the defense counsel's suggestion, the tan lines are significant for several reasons. That not only does it draw the viewer's gaze, making the breast and pubic area the focal point, but it suggests that this child is not normally naked here, and that nakedness is part of the consideration, and it is one of the DOS factors, and that why is this child on the beach posed with breast and pubic area prominently displayed when otherwise a 10 to 14-year-old is not usually naked outside. And that was, mentioned in Commonwealth v. Sullivan, where the court noted that it was troubling that this child was on the beach, adolescent, where, well beyond the age of the quote unquote copper tone girl. And so those factors would make that one at lewd as well. One image that we have not spoken about as of yet today would be the one of the child that was 2 to 6 years old on the beach. And that the focal point there was the young girl's vagina and how it was incredibly widespread, her legs, and that the camera angle was such that, it was focused in on the vagina. And it's a stark contrast with the background in that photo of the child who is playing in the sand and the genitalia is not exposed. And so that exhibit in itself shows the contrast between what would be a lewd exhibition and one where a child is just...
The toddler is at an age where it's not all that uncommon for a child to be playing in the sand at the beach. And it seems to me that you're parsing the details of that image very closely to suggest that the manner in which she chose to sit on the beach while she was playing with the bucket of sand is somehow lewd.
It's not just the pose, Your Honor, where, if that pose was, just happenstance that they were playing, the focal point here is the child's vagina, that the camera is angled such that, it is in and up towards the vagina. And that in of itself crosses line into making this a lewd exhibition. So all of the factors together make that lewd, not just, whether it's a pose or whether it's the focal point. Together, that is the lewd exhibition. And
you're saying that the focal point is the vagina because it was at the center of the image?
That's one piece of this.
Because anatomically, the midsection of the child's body in that image frame is going to be at the center of the picture. It was a wide enough perspective that it showed the other child playing in the background. It showed sand in the foreground. I mean, I understand your argument. I don't think that, speaking for myself, I don't think that's your strongest picture.
Thank you. Then, Your Honor, I will move on to if questions for discussing the counsel brought up at the end of the argument was the exhibit where the child is holding the cat. And this picture is significant in that the cat is a inappropriate attire, so to speak, or prop. That would be one DOS factor 3 in that it creates a double entendre with the, as the trial prosecutor argued, pussycat and the girl's exposed vagina, and that this, the focal point being her vagina, and that the source here originated from a Russian hosted website, which retired Lieutenant David McSweeney, as expert for the Commonwealth, testified had been previously seen in child pornography cases. But
if there were otherwise non-pornographic images on that website, that would not, the fact that the website hosted some pornographic images would not transform the others into pornography, would it?
Your Honor, that would be, so that testimony went to, I believe it was IMG SRC search term and website. This website with this exhibit was another one, Peekaboo, and that, Your Honor, there was no testimony of that one having other images that were non-child pornography.
But it doesn't matter because the question of whether this is lewd or pornographic is, of course, what we're here to decide. The fact that there are other images on a hosted site that are demonstrably pornographic does not somehow turn a non-pornographic image into a pornographic one, does it?
No, Your Honor, it does not turn a non-pornographic from pornographic, but the question of the source of the material is an important factor, which was brought out in both Commonwealth v. Rex and Commonwealth v. Sullivan. That source provides context to where did these materials come from, and the larger question of the statute, which is whether this child was exploited and the possession of this image further victimizes the child. And so in contrast to Rex, where the images were cut from a National Geographic, a sociology textbook, and brochure, here the reasonable inference of a Russian hosted website, which was known to hold pornography, is that it is reasonable inference this child was exploited in taking that photo. And so that would be the significance for at least 3 of the images that came from Russian hosted websites. I believe those were exhibits 13, 14, and 15.
If she had been holding a snake?
If she had been holding a snake?
Yes.
Well, the fact that it is a cat is significant. That is the design of the image.
I understand, but you know, she could be holding any number of different animals.
Yes.
And you know, it could be nefarious or it could be coincidental.
And even if it was another animal, the Commonwealth would suggest that the image remains lewd because not one factor is determinative here. We still have a 10 to 14-year-old girl posed with her vagina prominently displayed in the image. The background is minimal, so the focal point here is her vagina. So even if we, in a hypothetical, swapped out the animals, the image could still be found to be lewd. But it is significant here that the cat creates a double entendre. And so the Commonwealth would suggest that where defense counsel has contrasted the images and say they are more similar to Commonwealth v. Rex or Bean, these images are very akin to that image that was found lewd and exploitive in Commonwealth v. Sullivan. In Sullivan, the photograph, also originating from a Russian hosted website, depicted an adolescent girl. She was sitting on her knees on the beach with her legs separated and her pubic area partially visible. the focal point being her developing breasts and to a lesser extent, her pubic area. In finding the image lewd, the court noted that the girl's developing sexuality had been exploited by the taking and sharing of this photograph. And here, the 6 images, it's the same here. The girls have been sexually objectified. They've been exploited with a lascivious focus on their developing breasts, their pubic areas, and some instance exposed vaginas. The possession and viewing of these images further victimize these girls, and the defendant's conviction should therefore be affirmed. If there are no further questions, the Commonwealth will rest on its brief.
Seeing none, thank you both. That concludes the argument in this case. The case is submitted. We will take a 15-minute recess and resume argument in the remaining portion of our case, the civil portion of our list today at
The case is now being recorded.
Okay, good afternoon. We continue with our list with the civil portion of the hearing list today, the remaining 3 cases. The first of those is case number 2020 P432, the Durkin Company, Inc. versus the City of Leominster. You may begin.
Thank you, Your Honor. This case essentially revolves around a contract between the City of Leominster and the Durkin Company, by which the City of Leominster contracted to purchase janitorial services for the school year after they had laid off their public employee custodians. Later, after some public blowback, it became politically expedient to bring back the custodians, and the City of Leominster breached the contract, and essentially, since that point, has taken the position that Chapter 43, Section 29 of the General Laws requires the mayor's signature on any contract over $5,000 in the City of Leominster. Our position as the Durkin Company is that the school committee has exclusive authority to enter into contracts under Chapter 71, specifically Section 68 in this case, which gives the school committee the exclusive obligation and duty to hire janitorial services.
How does that help you when the school committee didn't enter into this contract?
The record below is sparse as to who specifically entered into the contract. It was signed by the superintendent of schools. Whether or not this was approved by the school committee is not clear from the trial record. I think that would be something that would be worth investigating on remand, Your Honor.
Considering that the mayor is chairman of the school committee, and he says he had nothing to do with it in his affidavit, why doesn't that tell us the school committee didn't approve this?
Well, he's only one member of the school committee, Your Honor. The remainder of the school committee could, in fact, have approved it, despite the mayor's disapproval as a member of the school committee.
Looking at the contract itself, it doesn't make it clear that the committee was the party to the contract.
That is correct, Your Honor. The only signatory is James Jolicoeur, who at the time was the superintendent of schools for the City of Leominster.
Right. So that, as I understand it, the school committee oversees the superintendent's activities, but the superintendent is not a part of the school committee.
If the school committee had authorized Mr. Jolicoeur to enter into this contract, he would thereby be authorized to do so. However, in this case, there's basically no discovery at the trial level from trial counsel. We have very little on the record. What's in the record attached to my brief and my sister's brief is essentially everything that was included in the trial record.
Did you object that summary judgment was premature because there hadn't been enough discovery?
I do object on. I would object.
Did you make that? Did you lodge that objection at the hearing or otherwise?
At the summary, I was not trial counsel, Your Honor.
I'm not asking about you. I'm just asking about you as the party, not you personally. No,
Your Honor. A 56F motion would have been useful at that time, but none was made.
But in the absence of a 56F motion, isn't that concern waived?
I don't believe so, Your Honor, because at the motion, it was a dual motion based on the motion to compel and the summary judgment motion. So at that same time, trial counsel was arguing that discovery was warranted and simultaneously arguing against summary judgment being entered. So I think that
that's not the equivalent of a 56F. He wasn't objecting to the progress of the summary judgment motion itself.
I believe that if you were to review the summary judgment hearing, that there was talk of the fact that there was not enough discovery at that time. They were looking for additional discovery.
Where is that in the record?
So, sorry, Your Honor. So, you know, the motion compels at it's record appendix 6 and thereafter. This was a dual motion where they were being heard on both the motion to compel discovery and the motion for summary judgment. Now, the motion to compel was denied at that time. The summary judgment motion was denied 2 days later by written order. However, I believe that them arguing about the motion to compel makes it clear that it's on the record that there was a disagreement that not enough discovery was completed at that time for summary judgment.
There may have been a disagreement about the adequacy of discovery, but that does not in and of itself equate to a contention asserted and preserved that it was improper to proceed to summary judgment. But let's not belabor the point. Let's continue. The cases that you cite and the authority, the statutory authority that you cite to suggest that the school committee has the authority to employ individuals as janitors or custodians, it seems to me is directed toward the employment of the janitorial employees that they have now reinstated. But the entry into a separate contract with a third-party vendor to outsource those services is different in kind from the employment of janitors, coaches, teachers, any other employees that the school committee is unquestionably empowered to employ as employees.
Your Honor, in the case of Eastern Railway, the Supreme Judicial Court talked about how a service to transport students was subject to the precursor to Section 29. However, in their decision, the court talked about not that it was the fact that it was a service versus hiring of individual people, but that it was a different statutory structure. So they were talking about how at that time, Chapter 40 controlled as opposed to Chapter 71. So I don't think it's critical, the fact that it's a service as opposed to individual employment. There's nothing in Section 68 that specifically requires that of Chapter 71. And there's nothing in the case law that specifically requires it to be individual employees versus a service.
Well, except that the cases that you cited all involve those situations and speak about it in those terms.
Eastern Railway does not, Your Honor. However, in school committee versus Gavin, it's simply easier to discuss it in those terms because it was specifically one individual employee that was the subject of the lawsuit. I don't think that forecloses the idea that these services, just because it's not individual employees, is any less under the purview of the school committee. In fact, the school committee may be remiss in not looking into these secondary services, as they may be much more cheap than hiring individual custodians, specifically public employee custodians, thereby allowing them to reallocate funds to places where they would help the students in their academic pursuits. And also, I would add that janitorial services are critical, as is pointed out by the SJC in Ring, as central to the purposes of the school committee. A clean school is a healthy school, and a healthy student is a better student. So I think these things taken into account, this money is appropriated to the school committee to accomplish all these goals in Section 71. So if by accomplishing their goal of getting a cheaper custodial contract, they can reallocate those monies to, meet their goals under other aspects of 71, I think that's within the school committee's authority and purview to do so.
It's not entirely clear to me where this resides on the overall analysis, but you alluded at the beginning to the reason why the school committee determined to step away from this contract as being political blowback. And I'm not sure whether any of that is relevant, the motivation. But assuming for the moment that it is, isn't there a worthy distinction to be drawn between the school committee's ordinary prerogative to employ teachers and coaches and janitors in the ordinary operation of the school and the much larger decision, sign a $1 million contract, not quite $1 million, but nearly $1 million contract to a third-party vendor to outsource the service?
Well, Your Honor, I think it's pretty analogous to having a CPA with public employee custodians. You're talking about a monolithic contract with public employees through a CBA, through the union. It's not dissimilar.
Not dissimilar, but the difference is, the question is really whether the mayor is the person who should have the final say on whether that's going to happen or not.
My point, Your Honor, the overarching point is that this money is appropriated by the mayor and by the city council pursuant to section 2.7D of the city charter. Once that money is appropriated by the city council with the approval of the mayor, it goes to the school committee, and the school committee does with it what they wish in order to meet their obligations under the statutory structure. So since it's already been appropriated and that appropriation has been approved by the mayor, I think it would be quite redundant for the mayor to have to sign off on every contract that's $5,001 or more, which would be most of the contracts entered into.
You're not suggesting there was a specific city council appropriation for this contract. Generally, the city just gives a number to the school committee, and then the school committee votes on how that money is going to go.
That's typically the way it goes, Your Honor. However, like as I discussed earlier, the record in this case on appeal is quite sparse. I'm working with what I have. I don't have specific information to enter into the record about the appropriations in this case. Is there anything else, Your Honor? So I will just go back one last point on the city charter. Section 4.4, subsection 4 of the city charter specifically states that the school committee has the duty and obligation to do these things. The way that section 4.4 of the city charter is worded is, got it here. I want to get it proper. It says the school committee is empowered to provide ordinary maintenance and repairs on all school buildings and property, provided, however, that no sum appropriated for a specific capital expenditure shall be transferred and used for any other purpose without the prior approval of the mayor and city council. So the city charter itself is saying, once this money is appropriated to the school committee, they can use it for any purpose relating to the ordinary maintenance and repair on school buildings and property. And the caveat to that is the last sentence. It can be used for that purpose, but if it's used for any other purpose, they need the approval of the mayor and the city council. So my reading of this is that the city charter says this money is appropriated, the school committee has the money, the school committee can do it with it what they wish without going back to get the secondary approval of the mayor and city council.
This is about appropriations for specific capital expenditures, which wouldn't be ordinary maintenance. It's saying that if there's an amount appropriated for some capital improvement to a school building, it can't be used for ordinary maintenance. Why would it go any farther than that?
Well, I think this opens the door, Your Honor, to a situation where there are situations where the school committee can make these contracts without additional approval from the mayor. It's not an absolute. Section 29 is not an absolute. We see that in the Gavin case. It's just a matter of where the court wishes to draw the line. Frankly, there's not a lot of case law on this specific aspect of it, but there are situations where Section 29 does not apply when the school committee is empowered by Chapter 71. It's just a matter of, are we going to have the mayor be in charge of every last contract in the city, or is the school committee going to exercise their long-held independence to meet their very complicated needs to our students? So with that, I will rest unless your honors have any additional questions.
No, thank you.
Thank you, Your Honor.
For the city.
May it please the court, Your Honors. My name is Deborah Ecker for the city of Leominster. The facts here are not in dispute. There was a contract that was executed by the superintendent of schools. That contract was not executed by the school committee. The contract was not executed by the mayor. And the mayor, in his affidavit, which is in the appendix, did not approve, did not give any type of authority to the superintendent to execute the contract.
Counselor, I noticed that the affidavit that I assume you drafted, there isn't anyone telling us specifically that this wasn't approved by the school committee. By the mayor, sure. But so how do we know it wasn't approved by the school committee?
Well, there are no meeting minutes that say it was approved by the school committee. That could have been introduced by council. You're right. In hindsight, should I have produced, there's no conversation, right? So in the school committee minutes that I'm aware of. And so there's nothing for me to produce. It would have been up to plaintiff's counsel then to produce those minutes during which this contract was discussed, during which the school committee voted to give authority to the superintendent to enter into it.
Why don't you have the burden when you're moving for summary judgment to have an affidavit? I'm on school committee, mayor could have added it in. I'm chairman of the school committee never voted on this, or, submit all the minutes of the school committee meetings around that time to show it. Why was it the non-moving party's burden?
Well, it is my burden to prove. You're correct about that, but it's proving a negative. So it never crossed my mind, honestly, until there is this argument about the school committee, that the argument was going to be, well, the school committee approved the contract, so therefore it's the superintendent, gave the superintendent authority. But it would have been an attempt to prove the negative. Here you have the mayor who sits on the school committee saying, I never approved it. I never gave the superintendent authority to do it.
But that's not the same. It's just, this gets us into Kuravasalis territory, right?
Correct. I understand what you're saying, but even if the school committee approved it, let's say, it doesn't help because it's not the school committee who has the authority under the charter, under the statutes, to approve a contract of $900-some thousand. It's a commercial contract versus an employment contract.
So let's talk for a moment about removal of waste from the dumpsters that sit outside of the school facilities. And I assume that they're going to hire one of the major hauling vendors to do that rather than to employ their own trash removal service.
I'm sorry, Your Honor.
No, but you see where my question is going. That type of a contract is something that requires, in your view, the mayor's signature.
It does, Your Honor. Yes, under the charter and under the statute and under the procedures that are established in the city of Leominster.
And is that, I assume that the city of Leominster has such a contract?
I don't know if they have the specific waste removal contract. I know in Discovery.
They have to have waste.
Right. I'm assuming that they do, but I have not seen it.
Right. And what you're telling me is that in order for that contract to be valid, the mayor has to have signed it. And therefore, we would presume that the mayor, in fact, has signed it in the regular course.
Yes. So in Discovery, what we did produce were contracts that the superintendent, there are 3 of them, that the superintendent had signed that had to be redone because the mayor did not execute them. Therefore, they weren't valid. So they had to go through the proper process. What occurred in the motion to compel is that not my brother, but his predecessor was looking for all of the contracts. We made them available. He could have gone, this was pre-COVID, to City Hall to review them. And that's what was discussed both at the motion to compel and motion for summary judgment hearing. He did not avail himself of that. Rather, in responding to discovery, we produced only those contracts we were aware of that the superintendent had signed, but then had to be redone because they're commercial contracts versus the cases that are cited by my brother, which are all employment contract. This, is a well-established area of the law that commercial contracts over $5,000 have to be executed by the executive authority of a city. In this case, that is the mayor, both under the charter and under the cases and under the statute. So, all right. So anyway, so it's our contention that it's not signed by the mayor. In the alternative, and I hear what you're saying, we did not produce meeting minutes, but it wasn't signed by the school committee. Instead, it's signed by a superintendent. The charter and chapter 71 does not give the school committee authority to enter into commercial contracts for the maintenance of the school buildings. Rather, it gives them oversight over the maintenance, how often we clean now during COVID, right? How we're going to sanitize when the kids come back to school. That does not translate anywhere in the statute or the case law with their authority to be able to enter into commercial contracts with whomever the vendors they're choosing to come clean the schools, particularly at this time. That again has to go through the city and their procurement process. So it's the city's position that because it's not a valid contract, because the mayor did not execute it, given the long and well-established case law, that one does, while it may seem unfair at times, enter into contracts with municipalities at their own risk. They have to know the process. They have to know who has authority to enter into such contracts. In this case, that process wasn't followed. The city then decided not to continue with the services because the contract wasn't signed by the mayor and was not enforceable. Therefore, I don't know if your honors have any other questions of me. I think
we see the issue. It's a single issue case, and it's an interesting question. You both presented it well, and I thank you for your arguments. The case is submitted.
Thank you, Your Honor.
Okay, and then I will call the case when I get that high sign.
The case is now being recorded.
Okay, proceeding with our hearing list, we reached the fifth case on today's list, case number 2020-P430. This case is impounded. It concerns the termination of parental rights. And I've reminded counsel to refrain from reference to any impounded materials during the course of the argument. With that background, Attorney Chenevert, you may proceed.
Thank you, Your Honor. May it please the court, Dana Chenevert for appellant mother. I want to note for the court that I was added as successor appellate counsel to this matter, so I did not write the brief. However, I'm here to argue mother's position, which is that the evidence is insufficient to terminate her parental rights, not return the child to her at the time of trial. The court based its finding of unfitness on domestic violence, I would say was the primary issue, in addition to mental health and substance use. And mother would aver that the domestic violence, the court's findings are insufficient to support a finding of unfitness in this regard because—
Could I interrupt and just ask one question to
Sure.
clarify before you get started?
Sure.
Does mother take issue with any of the factual findings, the correctness of the factual findings? I didn't see that in the brief.
It seems that no, there were no, there's no argument that the factual findings, the subsidiary findings, were not supported by a preponderance of the evidence, other than the fact that she was not actively involved in a relationship with Mr. H, I will call him for the purposes of this hearing. That DCF's evidence on this was scant, that she was actively involved. And the court's findings in this regard, mother does take objection, she does object to. She also posits that she was working on doing some education around domestic violence in her relationships. And to the extent that domestic violence did exist in the relationships, it had very little of no impact on either the child, which the impact is missing from the judge's findings. And also there was no impact on mother's ability to parent her, because even there's questions about whether the child was even present for any incidents of violence between mother and who the judge alleged was her current romantic interest at the time of trial. I would say that there was one incident where the findings firmly conclude that the child was present during an incident, and that was the incident with the child's father, on February 2011, which was the incident that triggered the ultimate removal. So to the extent that domestic violence was an issue, the findings are silent actually on an actual impact to the child and an impact on mother's ability to parent her. At the time of the child's removal, the child was in perfect condition. She had met all of her developmental milestones without concern. She was medically current. Mother's household historically was, and at that time, historically was clean and in order. The child had mother had adequate housing, which she had lived in for the previous 6 years. There were and actually the record does reflect that DCF was involved with the family for the preceding, 2 years at the time of the findings came out, and there were no concerns about mother's home or stability in the home or mother's ability to provide for her older child at that time. So as to the domestic violence, mother would posit that the evidence is insufficient to find her unfit, no impact on the child. And she was actually working on that at the time at the conclusion of trial. As for the other issues, mother's substance abuse or substance use, she had been in treatment and she had been consistent with her treatment. She was in compliance with her treatment at Habitat Co. and had been for the preceding 8 months, which the trial court did make findings about. And also, as far as mother's mental health goes, there was testimony and there was evidence, and the court so found that she was compliant with her individual counseling with her therapist, Mr. O, at the time of trial, and had been in compliance and been in session with him from October 2018 through the end of trial. So mother's stable housing, along with her active engagement in individual counseling and her compliance with her substance abuse treatment, actually are gains that the court failed to adequately consider prior to terminating mother's parental rights.
I don't want to cut you off on the anything more you want to tell us about the mother's fitness, but you also, in the brief at least, have an argument about about a procedural error warranting relief.
Yes, and that is it was a procedural error. It was a procedural error that the Department of Children and Families, so mother had stipulated to her unfitness it was February of 2018, and less than 6 months prior to 6 months lapsing, which is the 6 months allowed under General Laws, Chapter 119, Section 26C. The Department of Children and Families had filed for a review and redetermination, seeking to terminate mother's parental rights. And it's interesting, I'm laughing, but I found it interesting in the department's brief that they said, no, that's not actually what we meant at all. We captioned the motion, a motion for review and redetermination, but really what we were doing was filing a notice of intent, because that's what we wanted to do. We wanted to terminate mother's rights. Well, I think that argument is disingenuous. They captioned.
Could I interrupt you and ask this? Is there any place where the mother preserved an objection to that procedural issue?
It's not on the record. I could not find it in the record where there was an objection to the case moving forward.
On a review and redetermination, the department could, without seeking review and redetermination, as you say prematurely, the department could have proceeded toward termination at any time during the life of the case, correct?
I'm sorry. So your question is whether DCF at any point could have proceeded
to seek termination without calling it review and redetermination?
Well, I think that's debatable. Well, actually, no, I don't think they can. I mean, so the language of 26C, it says that a petitioner such as DCF or party may petition the court not more than once every 6 months for review and redetermination.
That's for review and redetermination. But if we step outside of the review and redetermination, the department may, having taken the children into custody and elicited a stipulation of unfitness, may change the goal from reunification to termination and proceed toward trial on termination, whether 3 months, 6 months, 8 months, whatever time has passed. Can it not?
Well, I believe no, I think what DCF can do is they can change the goal. They can change the permanency goal from reunification to whether it be adoption or guardianship. But under section 26C, they may not petition the court for review and redetermination of a previous stipulation of unfitness or its previous adjudication for 6 months. Like they have to wait 6 months.
But I don't think that the department, when they change the goal and decide to seek termination, is limited to the review and redetermination vehicle in order to accomplish that goal, that objective.
So I guess if I'm understanding you, Justice Green, you're saying that at any point, that's
always been my understanding, and the review and redetermination. And so it seems to me that there is something to the argument that perhaps the mother was misled at trial by the department's choice of the vehicle of a review and redetermination and all of the other procedures that attach to that, and was left in an adverse posture to defend against that effort. For some procedural reason. But number one, as Justice Hand has observed, there was no objection to that. And number two, I don't understand your argument to identify any particular prejudice to flow from that inapt captioning. I don't understand, and again, unless you can point me to something to the contrary, I don't understand that the department is confined to a 6-month waiting period and then proceeding through a review. And in fact, typically in my experience, the department does not proceed through the vehicle of a review and redetermination when it changes its goal.
Understood. However, this is the vehicle that the Department of Children and Families chose to use.
I understand that, but my point, and I will give you an opportunity to respond. I just, because the department may, outside of this particular procedural vehicle, proceed, the issue is not the 6 months. The issue is, was the mother prejudiced by believing that she was responding to a review and redetermination rather than simply a change to termination? And if so, why?
Well, I believe that prejudice in this context is when the time is shortened is inherent in proceedings such as these, where what's at stake is whether a parent gets to continue a legal relationship with their child. with a
I
child
thought we had
that,
already established that the time outside of the review and redetermination is not so limited, that the department could have, within the 6 months, have sought termination without regard to doing so under the vehicle of a review and redetermination.
but even in seeking to terminate within that period, they would need to, because there was a prior adjudication where mother stipulated to her unfitness, the focus should have been on a change in circumstance. If you look at the department's motion, which is included in the appendix, there's one tiny paragraph that they said that, you know, the situation is basically not changed, that the circumstances that under which mother stipulated to her unfitness existed, and they wanted to move forward with the review and redetermination. And at the time of trial, there was evidence that came in during the proceedings where the circumstances changed, but they changed for mother for the better. She was addressing her mental health. She was maintaining stable housing. Her substance abuse was she was in compliance with her substance abuse treatment, and her life, for all intents and purposes, seemed to be stable at the time of trial. So to terminate her parental rights at that time, it's the, you know, her gains, her recent gains, given her recent gains, it's not supported by the record. Arguably, I don't know if I can argue this, wasn't in the brief, I can't argue it, but the evidence at the time of trial did not support that grievous shortcomings that require that are required for the termination. Mother was addressing those shortcomings, those perceived shortcomings that she had stipulated to a few short months before, and was working on them while maintaining a very nurturing, securely bonded relationship with her little girl, visiting every week, only missing 2 visits between the time of removal and the time of trial. And those visits, even by DCF standards, went well.
Visits still weekly right before termination?
I'm sorry, I can't hear. Let me turn you up.
Were the visits still weekly right before termination?
The record that I just reviewed, yes, I believe that they were still weekly up until at least the time of trial, yes.
Beginning of trial or end of trial, or we can't tell?
I believe it was through May. Hold on, let me get that. I did make a note. Through May 2019. Through May 2019. I'm looking at every weekly parent-child visit. Yes, I don't see that DCF changed the frequency of the visit up through, well, they noted that she canceled a visit in June 10, 2019, but I don't see that any time between February 2018 and that time they had reduced the frequency of the visits to fewer than weekly.
All right. We'll leave it there. Thank you very much.
Thank you.
And we'll hear from, I guess, first the department.
Thank you, Your Honors. Carol Fazoli, representing the Department of Children and Families, the appellee in this matter. This is a case that demonstrates overwhelming parental unfitness on behalf of mother, and the court was correct in terminating mother's parental rights. Notably, one of the major factors that was evident here was domestic violence. And this was not only with mother as the victim, but also often as the perpetrator herself. What led this case into the removal was an incident where mother was found shoving the child through the window to the father, who is deceased in this matter. During custody exchange. Both her children were present. There's numerous findings that the children were present during this during many of these domestic violence incidences, which included the mother's older son's father, as well as the father who's deceased, as well as her current relationship. The fact that I believe my sister said that the children were not harmed, as we all know from well-established case law, witnessing the domestic violence can be harmed. In fact, there's an actual finding where the child was actually, the trial court found that the child was terrorized by the police because they had visited the home so many times. And this is prior to the removal. In addition to the domestic, the bigger issue with the domestic violence is mother's inability to address it. There was no findings with respect to her adequately addressing any of her domestic violence concerns. In fact, there's testimony on behalf of mother where she said that she liked to stand up to her partners to show who's boss. Besides that, during the trial, which began in February and continued February 9, 2019 to July 2019, mother was seen twice with her alleged perpetrator. The man, she said, is controlling over her and was preventing her from going to her domestic violence programs. So the court found that she did not adequately address her domestic violence. In addition, mother had substance abuse issues, which, although she did attend Habit OPCO during this case, there was 2 positive drug tests for both fentanyl and cocaine during this case. Finally, in addition, her mental health, there was findings about her being hospitalized due to suicide thoughts. And then, in addition, with the major problem with her mental health was her failure to address her anger management issues. Throughout the course of this case, there were incidences where mother engaged her own mother in the domestic violence, and also ex-girlfriends, and again, never addressed anger management with any of her programs. In fact, her current therapist, it was not part of her treatment plan. And also, in addition, there was criminal activity. There were 10 criminal charges that were pending or that had occurred from the removal of the child to the conclusion of the trial. And those criminal charges included assault and battery, intimidation of witnesses, a harassment order. All of this cumulatively showed the unfitness of mother, and that it would be unsafe to return this child to mother. With respect to the other issues, I believe Your Honor brought up the review and redetermination issue. The departments did prior to the 6 months, they did file what is a review and redetermination petition. Now, again, the trial, the actual termination trial, did not occur until well beyond the 6 months from the time mother stipulated to permanent unfitness. And clearly, mother was given, the purpose of filing that R&R was to give mother notice of that this was a termination trial. And I believe Your Honor is absolutely correct where he stated that at any time the department could have moved for termination of parental rights. This court in 2 different cases, custody of Catherine and adoption of Rona, have said that an R&R is a review and redetermination, is a re-adjudication of a prior custody order. The department was not seeking a re-adjudication of the prior custody order where mother stipulated to her unfitness.
Why did the department elect to proceed under that procedural vehicle?
The department elected to do that because it was labeled, it's typical in the courts where they want to give notice to the mother of their intent to go forward.
They can do that in any number of different manners, right? I mean, they could simply say they could file a motion, right?
they could have filed a motion, they could have filed a notice of intent.
So this muddies the water, it seems to me, in an unnecessary way.
Again, Your Honor, I would concede that the R&R is a misnomer in this case.
You're using it for something that it's really not designed for.
Your Honor, I would concede that that is actually was done in this case. However, again, the mother at no time objected to that procedural vehicle that the department chose. With it, the department, as I said, it still puts the burden on the department, which was done at trial. So there was no prejudice. This was a termination trial. Mother was represented by counsel throughout the trial. At no point did they object to going forward with the termination trial. And so there was no prejudice. Again, it gave notice that the department was seeking a further termination trial, which they could have done at any point during this proceeding. They chose this, and again, but again, there's no prejudice, and there was no objection on behalf of the parent.
Counselor, before you run out of time, I would like to talk about the visitation. To go from weekly visits to once every 12 weeks with no explanation seems strange. So I would like to hear how you can defend that.
So, and in my and in the appellant's brief, they do cite to the Zeldin case, which came out recently, with the question of the visits in this case did go, and I don't believe they were weekly. In fact, I believe the last couple of visits in this case were actually missed by the mother once they got switched to the department supervising the visits. Because prior to that, maternal relatives had been supervising the visits. So up until there was an incident at a daycare center with the grandfather, then the department took over. Now, with respect, why this case is very different from Zeldin. In Zeldin, that case was, number one, it was the child who was requesting more visits in that case. And they went from 52 to 4 a year. In this case, the evidence it's clearly within the trial court's discretion to decide how many visits or what's appropriate. And given the evidence in this case, where they actually had the foster father testify that he would support the relationship with the mother, where they had substantial evidence of mother's of the bond that they did recognize that mother had a bond with child, but there was sufficient evidence that the judge had before him with respect to coming up with what his discretion is. And that discretion really shouldn't be challenged. Unlike in Zeldin, where it was the child requesting more visits, in this case, if the child was unsatisfied with the number of visits, they could always get that adjusted through the permanency plan that goes on well after this case is over. So they could go into court and ask for more visits. So that's where it can be addressed if it was an objection. But in this case, I believe the evidence was clear in front of the judge that 4 visits were appropriate. But again, it's a discretionary decision on behalf of the trial judge, and we shouldn't revert that and leave it to his discretion.
Thank you. For the child?
Yes, good morning. May it please the court, my name is Diana Cowie McDermott, and I represent the child in this matter. I'd like to be clear, the mother has argued that the filing of what's called a motion for review and redetermination violated her due process rights. Respectfully, I would direct the court to the affidavit which was filed in support of that motion entitled Review and Redetermination. That motion makes clear that the department was seeking to terminate the mother's parental rights. That motion is in the record appendix. At no time did the mother object at trial to the motion, what was called a motion for review and determination. The mother filed a directed verdict. The mother never mentioned the motion for review and redetermination. She never mentioned the elements of a review and determination. The evidence was clear that the department was seeking to terminate parental rights. Of course, a motion under Section 26 is seeking a re-adjudication of custody only. The department in this case made clear they were not doing that. They were seeking to terminate parental rights. I would respectfully direct the court's attention to two cases. One, adoption of ILANA, that's capital ILANA. That's a former 128 decision from 2016. There, the department filed a motion entitled a review and determination. In that motion, the department made clear that it was seeking to terminate mother's parental rights. That motion was filed 1 month after adjudication. The trial was held 1 year after adjudication. On appeal, this court found that the mother had notice of the proceedings, an opportunity to be heard, and time to prepare for trial. And therefore, there was no due process violation. Any failure to observe the strict structure of Section 26, that being the 6-month period, was, quote, harmless beyond reasonable doubt. The mother in this case claims due process violation because the department filed the motion for review determination within three months after the adjudication. Again, adoption of ILANA makes clear that any motion filed within the 6 month is, quote, harmless beyond reasonable doubt. Your Honor asked whether the mother was misled. I repeat, her directed verdict did not mention review and determination. There was no prejudice to the mother. In fact, the mother was given more time to prepare for this case. Section 26 indicates that after an adjudication, any party may move the court or petition the court for a re-adjudication. That hearing cannot be held within 6 months. In this case, the hearing, whether it was called a review and redetermination or a termination trial, took place 7 months. There was no violation of this statute. Regarding the mother's temporary fitness, and again, I'd like to be clear, the mother argued that her fitness was temporary. The mother indicated on appeal that she has a plan for safety. However, the findings made clear that the mother consistently failed to recognize the effects of domestic violence on the child. The court also noted in its findings that the mother maintained a relationship with a male who they both engaged in domestic violence, and that this relationship, which maintained at the time of trial, put the child at risk of harm. The mother on appeal argues that her fitness was only temporary because she was engaged in anger management. I would like to point the court to the judge's findings that points out that the mother's aggression put the child at, quote, serious risk of harm. Regarding substance abuse.
I didn't understand that.
Excuse me. Regarding the substance abuse, the court found that the mother did not recognize the effects of her substance abuse on the child. Regarding visitation, my time has expired.
Why don't you finish the last point on visitation and then we'll wrap.
Thank you, Your Honor. The purpose of visitation is to assist a child from one home to another. The child has already made this transition. Of course, when the court decides whether to issue visitation, the standard is best interest of the child. It is not the best interest of the parent. The mother relies on Zeldin.
Okay, I think we'll leave it there.
Thank you, Your Honor. I would otherwise rest on my brief.
Okay, thank you all.
Thank you.
That concludes the argument in this case. The case is submitted and we will proceed with.
Interesting.
Wait a moment, Mr. Goff. We have to wait until we begin recording. And I will call the case when that happens.
The case is now being recorded.
Okay, that brings us to our sixth and final case on the hearing list today, case number 2019 P1830, Benjamin F. Goff as trustee versus the town of Randolph. Mr. Goff, you may proceed.
Members of the panel, may it please the court, I am Benjamin F. Goff, trustee of the Benjamin F. Goff 2004 Revocable Trust representing the appellant. This appeal is focused on whether or not the trial judge erred in granting appellee's Rule 50 motion for a directed verdict. Specifically, the appeal contends that the trial judge erred in not considering the prima facie self-evident facts, law of the case rulings, and the facts favorable to the plaintiff. As required by Rule 52A and Rule 41B2, the trial judge did not state the facts found or the rulings of law relative to the constitutional statutes and settled case law concerning the taking of private property without compensation, overburdening an appurtenant easement, and the public use of a private road. The prior findings of the lower court in the motions for summary judgment and the appellate court in case 2016-P1144 were supplanted by the non-factual assertions from an unsigned expert disclosure devoid of the facts of the case and the property rights statutes and law. At the onset of trial, the judge inferred that the opinions and conclusion of the land use plan expert enhanced her understanding of the case and would influence the judgment. Despite the evidence proffered at trial, which met the burden of proof for the taking and overburdening claims, the trial judge neglected to find that the defendant had taken private property without compensation and the town's appurtenant easement from Powell's Farm Road, a private subdivision road, was overburdened in contradiction of statutes and settled case law. Additionally, the trial judge erred in not requiring the defendant to produce rebuttal evidence and granting a directed verdict on non-specific grounds. The appellant plaintiff is legally due compensation for the unauthorized layout, construction, and public use of the temporary turnaround on Lot 4, 18 Powell's Farm Road. The appellant states that sufficient facts were entered into evidence at trial, along with the law of the case rulings, to meet the burden of proof. However, the appellant contends that with the prima facie facts, inference, and presumptions, it had a burden of persuasion as opposed to production. When the basic fact with it, by its nature, an inference that the presumed fact is true, in Massachusetts, the combination of the presumption and the inference create what is called prima facie evidence. As this court is aware, the law of the case rulings supply the ground rules for the case and influence how the trial will proceed. Absent any change of the circumstances, the court or judge is not bound to reconsider a case and issue a question of fact or law once decided.
Mr. Goff, Mr. Goff, if I may, I just want to observe one aspect of the law of the case doctrine, and that is that the law of the case may affect certain preliminary rulings, but it does not convert into evidence commentary on factual background that appears in earlier rulings from a non-evidentiary proceeding.
Okay.
Mr. Goff, the turnaround, I thought that was constructed by a private developer, not by the town.
The turnaround was approved in the Randolph subdivision plan. The developer followed that plan. There was an as-built drawing completed, and the town approved it and accepted that. So, in fact, the town did, in fact, approve the turnaround. If one considered Peter versus Haymarket Square ruling, it is the right to control that is determinant, and not the actual construction. It is the right to control. The rulings made by the trial court not challenged on appeal becomes the law of the case. The law of the case is generally applies if an appellant court has passed on a legal question and remanded the case to the lower court for further proceeding. The legal question thus determined by the appellate court will not be differently determined on subsequent appeal in the same case where the facts remain the same. An appellate court determination on a legal issue is binding on both the trial court on remand and the appellate court on subsequent repeal, given the same case and the same set of facts. The defendant oral motion for a directed verdict lacks specific grounds and failed to rebut the prima facie facts, inference, and presumption. The trial judge denied the as-built plan as relevant evidence. The plan was provided by the town of Randolph under Massachusetts General Law 66, Section 10, and it conclusively established that the temporary turnaround was constructed as approved by the planning board of the town of Randolph. Under Rule 44, this is a self-authenticating document in accordance with Mass Guide to Evidence 902. If the evidence rational tendency is to prove an issue in the case and renders the desired inference more probable than it would be without the evidence, it should be admitted. Now, regarding taking private property, the Fifth Amendment to the Constitution provides in pertinent part that property should not be taken for public use without compensation.
Mr. Goff,
regulation, policy, or procedure
Mr.
becomes
Goff,
a taking where the government requires the owner to
Mr.
suffer
Goff,
permanent physical occupation.
Mr. Goff, I believe that
Yes,
Justice,
Your Honor.
Mr. Goff, Justice Ditkoff has a question for you.
Could you explain to me why the as-built is self-authenticating?
Did you hear the question?
Yeah.
Justice Ditkoff said, asked you to explain how the as-built is self-authenticating.
Well, in accordance, the as-built plan is an approved document by the town of Randolph. Therefore, it's self-authenticating in accordance with Mass Guide to Evidence 902.
Mr. Goff, how do we know it's an approved plan by the town of Randolph? I don't see a seal or anything on it.
Approved by the town. And the town...
How do I know that?
Well, it was provided to me under a General Law 66, Section 10. I specifically asked the town of Randolph for the as-built plan, and it was provided. And that was proffered as evidence, and the judge refused to enter it. A permanent physical occupation, and lot 4 is physically occupied with asphalt pavement and guardrails. A permanent physical occupation occurs for the purpose of the rule not only when someone is put on someone's property, where individuals are given a permanent continuous right to pass to and fro, so the real property may continuously be traversed, even though no particular individual is permitted to station himself permanently upon the premise. And that is exactly what's happening with the turnaround here on Lot 4, 18 Powers Farm Road. Regarding overburdening the pertinent easement, the court has held that the Serbian state cannot be burdened to a great extent, and that what was intended at the time was granted by the dominant state. In this case, Randolph, the town of Randolph has converted the Parson parcel to a park. And that park is no longer is being used for other purpose than it was originally intended.
What was the original?
In addition, Parson Road is a private road, and the public is not entitled to use any portion of a private road in a subdivision. Private roads are subdivision roads. Roads are private easements are pertinent to the lots within the subdivision. It's for the owner of land within the subdivision who can establish applied grant. In conclusion, the appellant is requesting that this honorable court vacate the lower court judgment and grant judgment for the appellant plaintiff, provide monetary compensation for the taking of the appellant's property and for the public use of the turnaround, an injunction terminating the connection from Powers Farm Road and such other relief as the court may find just and proper. Thank you very much, Your Honor.
Thank you, Mr. Goff. For the town?
Good afternoon. These are difficult times, and I thank you for the opportunity to be heard. May it please the court. My name is Kimberly Salant, and I represent the appellee, the town of Randolph, in this matter. This is not a matter involving prima facie evidence. It is not a matter involving legal presumptions, nor is it a matter involving the law of the case. In terms of prima facie evidence, which is defined in Massachusetts Guide to Evidence, section 301C, it indicates prima facie evidence is where a statute or regulation provides that a fact or group of facts is prima facie evidence of another fact at issue. The party against whom the prima facie evidence is directed has the burden of production to rebut or meet such evidence. There is no regulation or no statute setting forth prima facie evidence in this matter. The cases cited by the plaintiff, which are spoken to in the appellee's brief, have to do with auditors' reports, arbitrators' reports. Nothing akin to that happened here. There are no presumptions here. Mr. Goff has tweezed from a 2015 Superior Court decision wherein Mr. Goff moved for summary judgment in that matter. The town of Randolph has never been a moving party on a 56 motion in this case. What happened is that there is a statement made by the Superior Court judge, which is nothing more than dicta, which indicates that presumably a portion, strike that, let me find exactly what it is. Presumably a portion of the subdivision turnaround is presumably on the plaintiff's land. That is not the law of the case. That is dicta. Dicta is defined in Black's Law's Dictionary as opinions of a judge which do not embody the resolution or determination of the court. Expressions in court's opinion which go beyond the facts before the court and therefore are individual views of author of opinion and are not binding in subsequent cases. So the presumption referred to by the appellant in his moving papers here is not a presumption at all. It is certainly not a legal presumption, nor is there law of the case present in this matter. What happened in this case was when the complaint was filed, I believe in December of 2014, the case sounded under Chapter 82 and Chapter 45. Reviewing those statutes, the town moved to dismiss this action. After that, Mr. Goff filed his first motion for summary judgment. A motion for a protective order pending the resolution of the motion to dismiss was filed by me. When oral argument came on those motions, the court said, I think we can probably resolve this matter by increasing and filling out the record. So what I'm going to do is I'm not going to take any action on the plaintiff's motion for summary judgment. He can refile it, and you will refile motions for summary judgment within a certain date and time. That happened, except that the town did not file for summary judgment. What the town did was a request under 56C, which, as this court is well aware, stands for the proposition that in the event that the trial court makes a determination that there are no genuine issues of disputed material fact, that summary judgment can be entered for the non-moving party. That's what happened. Mr. Goff appealed. The appeals court reviewed the record. Upon review of the record, the appeals court made a determination that summary judgment was not the way to go in this case because there were two genuine issues of disputed material fact. One, what, if anything, was taken from the plaintiff and what is the value of what was taken? And number two, was the easement overburdened? There are two easements in this case. Both of them are set forth not only in the deeds into the plaintiff, but are also agreed exhibits. The agreed exhibits in this matter are actually found, or copies of them are actually found in the supplemental appendix, volume 2 at pages 226 through 252. The first agreed exhibit is the Norway Pond subdivision plan that has been recorded. The second is, of course, the easement that this case is all about. It is an appurtenant easement by its very terms.
Counselor, I'm going to ask you a few questions about the exhibit.
Certainly.
Exhibit 1, that's the subdivision plan that was approved by the planning board?
Yes, that is the approved recorded plan. Yes. You'll see the recording information on that plan, sir.
And I hate to take you out of your order, but you could drop to exhibit 7
Yes.
and tell me exactly what that is.
Just give me one moment. Be happy to do that. Sorry, these things are paper clipped. I'm sorry. Exhibit number 7 was an exhibit that Mr. Goff wanted as an agreed exhibit. It is a 2009 plan of land for lots A and B prepared for Dana Powers. Dana Powers, just to refresh the court's recollection, Dana Powers owned all of that land. He was a farmer, hence Powers Farm.
So am I right in thinking that 7 is showing me the lot B that's referred to in the easement?
Are you right in indicating that?
The easement talks about how the easement is for the benefit of lot B. And this is, what I'm seeing on 7 is the lot B they're talking about, or is that a different lot B?
That's a different lot B. If you look at the actual easement itself, which is exhibit 2, I think it will help you. At least I find it helpful. I find it helpful. You will see, actually, if you look at the exhibit 1, which is the recorded plot plan, you will see, I'm not good with directions, but let's assume that west is to the left-hand side of the diagram. That's lot 4. Lot 3 is the lot that was eventually purchased by the town as conservation land under Article 97. Mr. Goff and his predecessors in title owned lot 4. The easement that's discussed, and this plot plan was 1986, final sign-offs were 1987, which is interesting because the easement that we're talking about was for the benefit of lot 3, which you'll see on exhibit 1, which is the lot owned by Dana Powers, which was purchased by the town as conservation land. I believe it was in 2009. The easement speaks to the fact that it is an appurtenant easement. While it does not necessarily have to say that, the easement itself says it's an appurtenant easement, so it runs with the land. Does that help at all?
So the easement is for the benefit of lot 3?
No. Well, yes. At that point it was, because that was known as lot 3. But that is now the conservation land. You will see that in the deed, the land that was purchased by the town. The conservation land, the Article 97 land is lot 3. This plan is 10 years before that. Is that right? Somewhere before that. I believe that the quick claim deed and reservation of easement for Article is Exhibit 6, which speaks to that 11.6 conservation, 11.6 acres of conservation land, excuse me. You had asked another question earlier, Justice Ditkoff, and I want to answer it succinctly.
I guess
I'm sorry.
What I was trying to figure out is
Yes.
Exhibit 6 talks about lot A and lot B.
Mm-hmm.
Trying to figure out what those two lots are.
You're trying to figure out what the two lots are in Exhibit 7.
No, well, Exhibit 6 talks about property shown on the plan as lot B, passing over a gravel road located on lot A. And I was trying to figure out what that's referring to.
Now, when I'm sorry to be so dense about this, but when you're taking that language, you're taking that from the grant of easement. You're not taking that from the quick claim deed.
I'm looking at the quick claim deed now. I'm looking at Exhibit 6. The
Okay.
quick reservation of easement.
Yes.
It's talking about lot A and lot B, and I want to know what those are.
Okay. I understand. The 11.6 acres is really on this plan, although it's hard to read, is lot A. You see that? It's the large, it's the 11.6. I wish I could show you. I don't know if you can. It's the 11.6 acres. You can see that it's on the plan. It's hard to read, but that lot A is the lot that the town eventually acquired.
On Exhibit 7.
Yes.
Okay, that's what I thought.
Yes. I'm sorry if I was confusing.
That's what I wanted to confirm, that the lot A they mentioned in Exhibit 6 is the lot A in Exhibit 7.
Yes.
Okay.
Yes. Another thing that I want to address before my time runs out is that what happened was we went to trial. There was a final pretrial memorandum filed. There was some disagreement about the final pretrial memorandum. You'll find in the supplemental appendix information regarding that. What I did was, because the court ordered a final pretrial memorandum, was when Mr. Goff refused to take any of my input or put in any of my revisions or information, I took his information, conglomerated it into one document, put in my own information, and I filed it with the court. Subsequent to that, the case underwent a Dober-Lanigan hearing, June 4th. It was filed months and months and months before that. And there was a complete disclosure of what Mr. Kenneth Buckland, the land use expert hired by the town, was going to proffer as evidence. In that regard, Mr. Goff did propound, I think it was 2 sets of interrogatories, 2 document requests. I know nothing, of course, about this Chapter 66, Section 11 public records request, because I was not privy to that and did not receive a copy of that. Several, I think it was over 105, perhaps, requests for admission of facts. He also moved for summary judgment several months after the final pretrial. And that motion was denied by the court, indicating that these are the 2 issues pointed out by the appeals court. There are disputed issues of material fact. Your summary judgment is denied. Then we went to the bench trial. I believe it was June 6th, June 10th, something like that, where the court made a ruling on the Dober-Lanigan motion, and the 12 motions in limine, which were filed by Mr. Goff, and I had filed 1 motion in limine in reference to the bench trial. The court ruled on all of those motions, and then the opening statements began. Mr. Goff summarized case law in his opening statement. The town of Randolph referred to what the evidence would show through the agreed upon exhibits and the stipulated facts. The stipulated facts, you'll find it for our ease of finding them, is in Supplemental Appendix Volume 2, pages 223 through 228. Mr. Goff at first produced and said nothing. The court indicated that he needed to call a witness. He said he had no witnesses. The court said, well, you can testify. So he began to testify. He finished his testimony. The court then, and his testimony consisted again of his reiteration of his summary of various case law. Then the court indicated, I will hear a motion from the defendant. The motion, which was kind of surprising to me in the fact that I expected Mr. Goff, based upon my conversations with him in the final pretrial, which he indicated would be 5 days, that he was going to call several witnesses, but he did not.
Counselor, I'm sorry to
that's okay.
Stop your chronology, but we're almost out of time, and I do have a few questions about the exhibit.
Okay.
Can you tell me what Exhibit 8 is?
Yes, I will. Exhibit 8 is, this is the 11.6 acres purchased by the town via Exhibit 6. It is the 11.6 acres of conservation land. That's a plan that was produced during the Conservation Commission proceedings. Sir.
Great. And Exhibit 9. What's Exhibit 9 showing me?
Same thing. Same thing.
One more question.
Absolutely.
Exhibit 10 is interrogatories.
Yes.
And I know that interrogatories 6, 18, and 26 were read to the judge. Did all the answers to interrogatories come in, or just an excerpt? What does that exhibit look like?
I did not actually have that as an exhibit. I have a complete copy of the answers to interrogatories in Volume 1. Actually, Mr. Goff produced them. Volume 1 on pages, beginning at page 255 in Volume 1 of the record appendix. Mr. Goff, due to the doctrine of completeness, read the entire answers to 6, 18, and 26 into the record.
Thank you.
You're welcome, sir. I see that my time has expired. I apologize for that.
I see Justice Ditkoff has no further questions. Justice Hand?
No, thank you.
Okay, I have none either. That will conclude the hearing in this matter. We are in recess. The case is submitted.
Thank you.
Thank you both.